Thank you. So welcome to the NYU Law Forum, and our topic of conversation for today, investigating Mar-a-Lago. I'm Ryan Goodman, and as many of you know, the NYU Law Forum is a discussion series sponsored by Latham & Watkins with programs scheduled throughout the academic year on current events, legal and public policy issues, and intellectual ideas. Today's program is also co-hosted by the Reese Center on Law and Security, where I'm a faculty co-director. And through its research and programming, the Reese Center works to elevate and advance the public dialogue about the most urgent national security law and policy issues of the day. And today's topic is one of those. I'm honored to be joined by an extraordinary panel of experts in which I'll just serve as the moderator. Before turning to an introduction of our speakers and the conversation itself, I just have three logistical items. So logistical item number one is about CLE credits for people in the room and on Zoom. So here I'm going to just read verbatim so I don't get anything wrong. Please note that this event has been approved for one New York State CLE credit in the category of areas of professional practice. The credit is both transitional and non-transitional. It is appropriate for both experienced and newly admitted attorneys. I will be announcing the CLE code later in the event. A second logistical item is that I'll leave room in our conversation for questions from the audience, in which you all can just come up to the microphones that are in the room. And then the third logistical item, most important, is lunch for students. And I'll read this one verbatim as well. Apologies to those of you who registered for a lunch. Our lunch delivery was a bit late, but feel free to pick one up on your way out the door. So let me introduce the speakers briefly, because you have their full bios in the program, and they're also extraordinarily well known. And I'm introducing the speakers from my left down the panel, which is also alphabetical. Bob Bauer is a professor of practice at New York University School of Law and a distinguished senior fellow at the Reese Center on Law and Security. I'll highlight two aspects of his professional career. He served as White House counsel to President Obama from 2009 to 2011. In 2021, President Biden named him to co-chair the Presidential Commission on the Supreme Court of the United States. Bob is a co-author with Jack Goldsmith of one of the most important books, in my view, on reforming U.S. governance and the rule of law, called After Trump, Reconstructing the Presidency. Carol Leonnig is a Pulitzer Prize-winning reporter who has worked at the Washington Post since 2000. She won the 2015 Pulitzer Prize for her work on security failures and misconduct inside the U.S. Secret Service, a 2014 Pulitzer Prize for revealing U.S. government secret surveillance programs of Americans through the disclosures of Edward Snowden, a three-time winner of the George Polk Award for investigative reporting. Her two recent books are Zero Fail, The Rise and Fall of the Secret Service, and with Philip Rucker, I Alone Can Fix It, Donald J. Trump's Catastrophic Final Year. Mary McCord is executive director at the Institute for Constitutional Advocacy and Protection, ICAP, and visiting professor of law at Georgetown University Law Center. I'll highlight just a few aspects of her professional background before Georgetown, which is she served as acting assistant attorney general for national security at the U.S. Department of Justice from 2016 to 17. Before that, she was principal deputy assistant attorney general for the National Security Division and assistant U.S. attorney for nearly 20 years at the U.S. Attorney's Office for the District of Columbia. Andrew Weissman is professor of practice at NYU School of Law and a distinguished senior fellow at the Reese Center on Law and Security. I'll highlight just a few aspects of Andrew's professional background. He was lead prosecutor in Bob Mueller's special counsel office, chief of the fraud section of the Department of Justice 2015 to 2019, and previously served as FBI general counsel. So you can tell how obvious it is that we are really privileged to have these experts on this topic, and almost on any topic that is of pressing national security concerns today. So it is an extraordinary topic in an extraordinary time. There is an ongoing criminal investigation of a former president of the United States under the Espionage Act and other federal criminal statutes. It's even more extraordinary because many learned legal experts are saying that it is not a question of could the Department of Justice indict a former president, but should the Department of Justice indict the former president. And some experts are even saying it's not a matter of if he'll be indicted, but when and where he'll be indicted. Just a few key data points I thought to draw from the public record and the chronology of events, and then we can set it up for discussion. And I thought to just lay some of the factual groundwork, because if we're going to talk about the law, we need to establish a kind of common set of facts, and then not so common set of facts, more in the realm of speculation or what's being reported or what's known and unknown. So in fact, my first question will be to Carol Leonnig to try to get us deeper into the facts. So just the quick chronology, so we're on the same page in terms of what's publicly reported. January 17th to 18th of 2022, after a drawn-out, difficult process, President Trump agrees to turn over 15 boxes of materials to the National Archives that he's kept at Mar-a-Lago. Intermixed in the boxes with personal belongings or other records, and the archives finds highly classified materials, in fact 184 classified documents. The National Archives then decides to refer the matter to the Department of Justice for investigation after the surprise of seeing these classified documents in the 15 boxes. So after the return of those boxes, the U.S. government determines that more are missing. On May 11th, the Department of Justice issues a subpoena for all documents marked as classified. And then on June 3rd, the Department of Justice and the FBI come to Mar-a-Lago at the invitation of the former president and are handed by his counsel 38 documents with classified markings pursuant to the subpoena. But the U.S. government thinks more are missing and gets a court-approved search warrant that is executed on August 8th at Mar-a-Lago, in which the Department of Justice and FBI recover 103 documents marked as classified and 46 empty folders with classified banners. And according to the most recent reporting, so all of that is in government documents and Department of Justice filings and the like. According to more recent reporting, which is not as reliable as existing documents produced by the government, the Justice Department thinks more are missing. And more are missing that they've actually, in the last few weeks, issued a demand that President Trump turn over additional documents marked as classified that the Justice Department thinks are still within his possession. So to open up our questions and start getting at the facts, and then we can start to get at the law that relates to the facts and the like, I thought to ask Carol just an opening question. How much of the current situation that we're in could be explained by chaos at the White House in the transition period and disorganization among Trump and his staff? That's one part of the factual question I think would be very helpful, because so much of the law depends on the answer to that question. And then another couple questions that go along with it. What do we know about the actual content of the documents that have been held at Mar-a-Lago? I can name the number that have been classified, but what do we know about the substance of those documents? And lastly, probably most in the realm of speculation, what do we think about, or what do you think about as the reasons that President Trump may have wanted to retain these documents?
Well, first off, thank you all for coming today out of the beautiful sunshine, and you could have been on the square chomping on those chips, but instead you instead you agreed to come in here and hear from us. And I have two quick things to dispense with before I answer Ryan's three good questions. And one of them is to say that, just to put in context of what a hallowed panel is in front of you, and I'm not speaking of myself, each of these three individuals are people that I was trying to break down their door at various stages in my career to answer my questions. And as I remember, some of them blew me off pretty good.
But we're willing to talk to you now.
I had a really good scoop involving Andrew Weissman, and I was foiled at every turn. But I'm glad to be able to socialize and intellectualize with all of them now. The second thing I want to dispense with is Ryan remarking on the reliability of the reporting as opposed to the DOJ filings. I will just say that that is genuine. It makes sense to me, except I and my competitors at the New York Times, the two that we look most closely to each other, we have availed you of information that you later learned about in DOJ filings. We provided early information that was borne out by the Department of Justice statements in court, but we pre-reported that. And each one of those has been factually true. The reason you know that he had classified records, the reason you know that he resisted the Department of Justice, the reason you know that he was advised to turn them over is because we told you before the Department of Justice did. I'm not blaming them, just gonna put in a stomp for the press. So your great questions, very good ones. Chaos. Can chaos explain what has happened? There is no question, after covering Donald Trump's presidency, that is one of its hallmarks. And indeed, in the last year of Donald Trump's presidency, which wasn't a heck of a lot different than the first 3 years, but in the last year, he, according to our reporting, was stuffing records into boxes indiscriminately that he just thought were interesting. He was taking to the executive mansion from the Oval Office materials that had been provided to him in national security briefings, just saying, I think I'd like to hold on to this. So that's pretty chaotic, and that's a breakdown of every norm that I can imagine. Actually, probably Bob Bauer can speak most directly to how that really goes down in a normal presidency. But my understanding is a mill aide takes that document back from the president and says, okay, we're going to take this back to lock and key. So those norms had been busted throughout Trump's presidency and much more so in the final year. However, chaos cannot explain a former president resisting for months requests from the National Archives to return key records that they know are missing. It cannot explain a former president resisting the advice of his former White House counsel and deputy White House counsel and deputy's deputy White House counsel. It cannot explain a subpoena having a response, a May 11th subpoena having a response that misses more than half of the classified records that are, to our knowledge, at Mar-a-Lago. There may be more. So I would say I'm in the camp of no, that cannot explain it. Your second question was about the contents. I and my colleague Devlin Barrett, who covers the Department of Justice, wrote a story about also beat the Justice Department in telling you this information, that when the FBI went asking for everything, one of the things they asked for every classification of classified records known to man, but when they asked for them, one of the classifications relates very specifically to nuclear records. They didn't know that they would find them. They wanted to be sure they got them if they were there. And what we learned in a subsequent story, what we learned and reported in a subsequent story is the most sensitive material that was found at Mar-a-Lago that could cause imminent danger. Forgive me, Mary's going to correct me on the language on this. Could cause instant danger. Grave danger. Grave.
Well, it depends on which level we're at, right? Are we at secret
We're
or
at,
top
we're
secret
at
or
TSI, TSSCI. Thank you. And those fell into two categories. One were material about foreign governments' nuclear capabilities, and we don't know whether that's a foreign adversary or a foreign ally. Both are problematic. And the second category were documents that were so closely held in special access programs that some of the highest level national security officials in the government did not have authorization to look at them. They had to have the president and a member of the cabinet and/or a member of the cabinet give them read-off permission in order to continue the investigation. So that's stuff that usually involves, again, Mary's going to backstop me on this, usually involves human sources and intelligence gathering methods that the United States doesn't want anybody to know that we have, or else our national security is at risk. Third question, I believe, was reasons. I am a reporter. I don't like speculating until I can publish with great certainty what we think and know has happened. I can't speculate what his reasons were. I can tell you what sources have told me about Donald Trump, which is that he liked to brag, that he had special gossip and secrets that other people didn't have. He loved to show people the Kim Jong-un love letters. One thing on the braggy kind of dirt, that he liked to know things other people didn't know. He boasted to some of my sources that he had a special top secret file on Emmanuel Macron. And you've probably seen some reporting, not in the Washington Post, but you've seen some reporting that indicates Trump boasted that he had intelligence gathered that was about the sexual life of Macron. So I offer you that as possibilities.
Thanks. And I guess I want to, in conversation, say I may have chosen my words poorly because I think that the reporting is like Pulitzer Prize worthy that we've gotten. And in particular, the Washington Post reporting on the nuclear materials is something that, in terms of public education, is enormous. There's public polling that actually shows the public is very concerned about that particular revelation.
Thank you.
So next, just want to turn to Andrew, now that we have a sense of some of the fact base, and talk about what are the kind of key crimes or parts of the federal criminal statutes that where Donald Trump has the greatest legal exposure, and then just to turn it in the other direction, where do you think he also may have the less legal exposure than many public commentators otherwise suggest? Where are some of the weaknesses and the arguments that are being raised against him?
Sure. So this is going to be the sort of drier part of the presentation after Carol's speaking about nuclear codes and the sexual practices of the president of France. So I think of this in sort of two buckets. So crimes that relate to espionage and relate to sort of the retention of documents, and crimes that relate to obstruction. And then a second overlay of that is it's important, I think, to think about those two buckets beyond what is in the known search warrant for Mar-a-Lago. That identified 3 crimes, but the Department of Justice wouldn't be limited if it were to charge the former president to those 3 crimes. So focusing first on this sort of espionage type crimes, each one sort of has a potential problem that depending on what the facts are, and we don't really know as much as we, obviously as the department, those can all be overcome. But for 793, which got the most attention, which is the espionage statute, has a problem that I'm not going to steal Mary's thunder, but the real issue there is it's the improper retention of information that is NDI, National Defense Information. If you notice, I talked about retention, and that is because precisely of what Ryan and Carol talked about, which is not focusing a jury on the issue of what happened at the White House, but rather what happened at Mar-a-Lago, because this whole issue of could something have been sort of lost in translation, and there was a rush, and the former president didn't want to leave the White House, and sort of the chaos can't be a defense if you're talking about the retention at Mar-a-Lago for 18 months. The problem with 793, the Espionage Act, is the NDI component of that, which is the documents don't need to be technically classified, but you would need to show the jury that this is national defense information. I'll leave to Mary sort of the internal debates that she and I have been part of on how to use that. The second statute that was cited is 2071, which also is about sort of improper retaining of documents that were filed in a public office. I personally think that, although there's very little law on this, and there's some lower court cases, I think there's some technical issues there. There's good law to support in the lower courts to support the government that these were technically filed with a public office because it's the White House. But it's not totally clear to me that I'd want to have that be the sole charge, and that you could easily end up seeing 5 justices or more disagreeing with that interpretation of 2071. My particular favorite, which was not charged in the search warrant, is 641, and I think it's probably because Mary and I both started as career prosecutors in the U.S. Attorney's Office, and 641 is like a standard crime, and that is just stealing government documents or converting government documents to your own. It's charged relatively often, and it's really easy, and it avoids some of the problems Mary's going to talk about. The biggest downside to 641 is just sort of the look of it, because it encompasses, if the former president took a menu from a state dinner, or these, Kim Jong-un love letters, although those are actually more serious than people think, because they are historically important and should be at the archives. But it just sweeps so broadly. But it does solve a lot of issues. Then you have the obstruction type statutes. So 1519 is this very broad statute that came into play post-Enron that deals with the destruction or concealing of documents to interfere with any matter in front of an agency of the government. It's incredibly broad in its scope, and it was intended to be incredibly broad. And that would include concealing documents from the National Archives, so for that whole time period, the 18 months, and the time period of concealing documents from the Department of Justice, which is a shorter time period, but also could be charged, because those are both agencies within the definition of 1519. Some of the glitches that I think haven't gotten enough attention is until Alex Cannon came forward in the reporting, that is the lawyer who, the reporting said that the former president was sort of personally involved in deciding what would be given back to the archives, and thus also what wouldn't be. And also that he didn't want to sign a certification. Until then, I would have said that 1519 had some big gaps in it, because we really didn't know, and we still have some gaps about what did the former president actually do. A typical defense in a case like Enron and any CEO type case is that person says, hey, this was beneath me, I don't know what underlings did, and I wasn't really involved in it. And so you need to connect up the knowledge and intent of the senior person. So the lawyers who made various representations, it's going to be really important for them to be interviewed about, for instance, who told them that everything had been returned, who told them that everything would be found in a storage bin when we know that things were found in the former president's office. Presumably that is going to be the former president, but as we were talking about beforehand, right now, one of the lawyers, Corcoran, seems to be very much in the hot seat in terms of what exactly he knew and what he said, what he was either told by the former president. And then the final piece is that the DOJ grand jury subpoena that was issued in May that received some responsive material in June is somewhat oddly worded, because it is directed not to Donald Trump himself. It is directed to the office of Donald J. Trump. And so the certification was about the office of Donald J. Trump, not Donald Trump personally. There probably are some good factual arguments that the government can make as to why that should encompass all of these documents, but from the outside, one of the questions I have is why the department didn't cover itself by issuing 2 grand jury subpoenas so that it wouldn't have to deal with this potential factual issue of Word documents that were taken from the White House all within the possession, custody, or control of the technical entity that was served with the grand jury subpoena.
And then also just to add a little element to it on the question of how involved Trump was, and then back to the reporting. So the Washington Post has actually reported just last week that Trump was personally involved in packing some of the boxes in January of 2021, and then has previously reported that he was involved in packing the boxes for the return of the 15 boxes to the National Archives in January 2022, and that he did so secretively and didn't allow his aides to know what he was doing when he did it. So Mary, kind of, Andrew's already kind of pointed us in this direction, which is, can you talk to us about the internal debates that might go with cases like this one, or this one in particular, as you think it might be happening, if we're talking about some parts of the executive branch that are forward-leaning, perhaps, on criminal accountability, and other parts of the executive branch within the intelligence community and counterintelligence that are very worried about having to disclose classified information or things like that in a criminal process, and then how that can be reconciled or not?
Sure, thank you. And just, I haven't mattered to dispense with as well, because although I have occasionally told Carol no, I have also let Carol interview me on my back porch a day after surgery while under the influence of narcotic painkillers for her book. So there. So who took advantage of it?
One of the best interviews ever.
She did allow me to fact check it later when I was, not under the influence of painkillers. But at any rate, so I think, I hope people really paid attention to Andrew breaking down these offenses, because before I get to your question, Ryan, because there's so much swirl and speculation out there right now in the news media, and I'm not talking about Carol, and in social media about the Justice Department has to bring charges, et cetera. And it's never as simple as it sounds. I mean, when you've prosecuted cases like Andrew and I have, you have to think of every single detail, right? And every single thing has to be sufficient to prove every element of the charged crime beyond a reasonable doubt, or you cannot ethically bring a charge. So these gaps that Andrew's pointing out, and I'm not saying it's not a doable thing, but it's never as simple as it seems for those who are, tweeting 240 character tweets or whatever they are. So the other big issue when we are talking about national security related offenses, and not all of these are, of course, because as Andrew indicated, some of the potential charges here have nothing to do with the Espionage Act or really national security. But when we're talking about where most of the attention seems to be is on the classified documents, right? That we now know, multiple tranches of classified documents have been found at Mar-a-Lago and retrieved from Mar-a-Lago, even after many requests to get them, and there could be more there. And so when we talk about potentially bringing charges that would involve an Espionage Act offense or another national security related offense where the classified information or national defense information is at issue, we have two competing interests within the executive branch, right? So we have the intelligence community that really owns that information, right? So classified information is obtained by virtue of various intelligence authorities, statutory and other authorities, by the agency that obtains it, right? Whether that's the CIA or the FBI or the NSA or the other alphabet soup of national security agencies. They're the ones at the highest levels that classify it. They're the ones who sort of control the access to it. And their reason for existing is not to bring criminal prosecutions for people who mishandle classified information. Their reason for existing is to protect our national security by using authorized intelligence collection methods and sources to obtain information that will protect the security of the United States. That's not just defensively militarily, but that's also our crown jewels, our intellectual property, our technical capabilities that are necessary to sustain our economy and our livelihoods here in the United States. It's many things beyond simply, we just gather classified information to, pass it around and talk about it. It's really critical mission stuff. And they, frankly, would prefer no criminal cases ever be brought, because every intelligence, collection and investigation is about continuing to make us smarter when it comes to defending the United States against all types of threats. And so they would rather the collections just continue on and on and on without the prosecutors ever knocking at the door and saying, hey, we want to use some of that because we want to charge somebody for mishandling it. So that's their interest. On the other side, of course, is the criminal divisions of the FBI and the Department of Justice who are concerned about accountability. And when they see crimes, potential crimes involving national security, including the mishandling of classified information, obviously also including the transmission of classified information to those not entitled to receive it, and other national security offenses, they want to hold people accountable for that. And particularly in a case like we're talking about now with President Trump, who hasn't shown any willingness to sort of play by the rules, right? If he had just simply, under chaos theory, if he had had a thorough forensic review or search of Mar-a-Lago and Bedminster and Trump Tower and, had outside experts come, well, he'd have to be people who could see classified information, although anyway, if he'd had done a real review and turned everything over and kind of been upfront about it, I don't think you'd see any real claims for accountability, because it would be like, okay, we're all right now, we don't need to keep pursuing this from a criminal investigative standpoint. But that's not the way it's happened, and that's why we're seeing things like an investigation into obstruction of justice, because the department has consistently come back, supported by the FBI, developing additional probable cause of potential additional classified material at different locations. And so the department has an interest in criminal accountability here. Now, here's where it gets interesting, because there's an inverse relationship between the sensitivity of the national defense information, classified information, and the ability to prosecute it. And that's because the more sensitive it is, the more likely that intelligence agency is going to say, no way, DOJ, are you using that at trial. Because you can't just go into trial and say to the jury, there was classified, and he had it at his estate. You have to show them and admit that this is actual national defense information, the disclosure of which could cause anything from substantial harm to exceptionally grave harm to the national security. And so that means admitting it's real stuff. And the intelligence community, if they have an ongoing interest, they are not always going to want to do that. So that means sometimes the DOJ has to find the less sensitive information. And that's also the information that maybe a jury is going to be less moved by, right? A jury is going to be more moved by the really serious stuff. So it's a very strange interplay between the criminal investigators and the intelligence community of negotiating when it comes to, can we bring a case? DOJ, criminal doesn't just get to make that decision. The intelligence agency can pull the plug when they say we're not going to go along with it, because they own that information. So, these, as we continue to talk about this today, these are the kind of discussions and debates that will be taking place, and I was involved in many of these, Andrew was involved in many of these, will be taking place between the department and the intelligence community as they look to whether a 793 offense or other Espionage Act-related offense is feasible.
Thanks. So I want to turn to Bob to start discussing some of the constitutional questions that have come up throughout this episode. And one in particular is executive privilege. So many have said that there's no such thing as a former president having the ability to invoke or assert executive privilege. And many have said there's no such thing as executive privilege being intra-executive branch, that it's only a separations of power principle regulating the disclosure of information from the executive branch to the courts or the Congress or the public. But aren't both of those propositions, I guess, and to put it flatly, false? Both of those propositions are false. Doesn't the Presidential Records Act itself contemplate a former president asserting executive privilege? President Obama passes an executive order elaborating the procedures for the Presidential Records Act. It itself explicitly contemplates a former president invoking executive privilege. And I think, at least in my view, the most plausible reading of both of those is it includes the former president invoking executive privilege in order to halt the archives turning over materials to other parts of the executive branch. So what is the right way of thinking about it?
I would put the answer into two parts. How it seems that the law is developing, and then second, which goes more to reform, what is the right way to think about it, which may not be the direction that the law is developing. Let's begin by saying there is nothing in the Presidential Records Act or in any executive order, including the one issued by President Obama, that was meant to guide the disposition of executive privilege claims by current and former presidents that can fundamentally establish, modify, or limit in any way executive privilege as a constitutional matter, because executive privilege is a constitutional doctrine. It's a constitutional right, if you will, if you want to put it that way. The Supreme Court has found that the president had a confidentiality interest, has held it on a couple of occasions, has a confidentiality interest that can be redeemed by the invocation of executive privilege. Now, let me emphasize, former presidents, they've said, do have that kind of interest, but it's been, on the court's part, vaguely and tentatively advanced as a proposition, simply because nobody's quite sure how far that goes. And I want to say, by the way, toward the end here, without going immediately to my conceptual objections to all of this, I just want to say that there's some real problems in the way, and that's one of the reasons I think the doctrine has been sort of vaguely stated, or the proposition has been vaguely stated, that former presidents have a confidentiality interest, and as you point out, that's reflected in some pieces of the law that seem, as you put it, to contemplate that a former president can assert executive privilege. In the Supreme Court's most recent statement on the subject, which bears on the current circumstances on President Trump's legal plights, the Supreme Court has said that there is a question, it describes it as a substantial and serious question, of whether a former president can assert executive privilege and prevail over the contrary conclusion of an incumbent president. So as you know, President Biden has said the extraordinary circumstances of January 6th are such that they overcome any claim of privilege that President Trump could assert with respect to those matters. And the Supreme Court has made it very clear that that is a serious question. That's their view, that it's a very serious question. And in a concurrence, Justice Kavanaugh said that he thought it was pretty clear, based on the precedent, that a former president could assert executive privilege because there had to be some continuing interest in the president's confidential interest here, or there had to be a continued interest that justified the invocation of the privilege, or what would it mean to have executive privilege at all? If every president knew that their interest in confidentiality would only be protected up to the end of their term, then what would be left of that confidentiality interest? The next administration could simply choose to disregard it. So both on this theory, both incumbent and former presidents have a stake in the preservation of that confidentiality interest through the invocation of executive privilege. So that's where things lie, that nobody's quite sure where the Supreme Court will go on this. Kavanaugh indicated as well that there may be some limits on how much a president or how strongly or successfully a former president could assert executive privilege. And those limits might be, for example, how much time had passed since the end of that president's term, that there was some dilution of that interest potentially over time. Not that he concluded that, they don't have a case in front of them to test that proposition, but he indicated he wasn't putting a former president's rights to invoke the privilege and a current president's rights to invoke the privilege on the same plane, but nonetheless, they recognized there was a substantial, or they stated their recognition of a substantial and serious question about a former president's right to invoke the privilege, even if an incumbent president objected. So that's where matters stand. There's some lack of clarity here, but the law seems to be going in the direction of some right, and I want to emphasize this, right, that a former president, however limited it might be, can assert and seek relief in the courts on. Now, I can hold my broadside on this view if you want. Okay.
Oh, no, don't.
Okay. So I want to be clear that this is not for me, even though I think it's clear I'm a Democrat and worked for Obama, worked for Biden. This is not for me about whether or not this particular former president has to be thwarted in the exercise of some constitutional right so that we can successfully prosecute him. This is not a Democrat versus Republican issue, as Professor Goodman pointed out. I've written on the subject of presidential power, and I believe very strongly that we have to approach these questions broadly from the standpoint of whether either political party can live with a particular doctrine, whether they think a particular place where the constitutional law lands is one that they're comfortable with, irrespective of whether they occupy the Oval Office or the other party occupies the Oval Office. And my complaint here, I just want to stress something. The former President of the United States is a private citizen. End of story, a private citizen. I have all sorts of things I could say which are outside the remit here about post-presidencies as a concept. I think a post-presidency means you're in private life. And if you choose to undertake charitable activities, good for you, but there ought not to be any institutional expectation that you have some continuing obligation to the public or particularly continuing official responsibilities to which might attach some legal right. I don't understand that at all. The presidents in their private lives, as former presidents, have maybe political ambitions to run again. They might have business interests. They might have a whole host of reasons why they assert executive privilege in a particular situation to prevent the disclosure of particular documents. It is also true that incumbent presidents have political ambitions, for example, to win re-election or to advance the prospects of their political party. But as a constitutional matter, we have to assume, as incumbents elected to discharge their obligations under the Constitution, that their predominant concern is with the national interest, and that they make these judgments in the national interest. And if they don't, I mean, there are obviously ways that that gets addressed. So the notion that a former president has a legal right, as distinguished from a legal interest, a legal right that that former president can seek to pursue in court to overcome the objection of an incumbent president, I regard as very, very dangerous. Now, there are ways of addressing that that I can leave to one side for the moment, if you'd like. There's a way to account for that confidentiality interest of former presidents, and I think that confidentiality of interest of former presidents has to be accounted for. I think it is a significant interest, but I don't think it should be a legal right, and I don't think it should be viewed in any way as on a plane in any sort of having any parallel significance with the rights of an incumbent president. But we're going to see how this particular law develops.
Thank you. So I want to ask a question that cuts across, in a certain sense, information that's in the public record through reporting, but information that might be available to prosecutors. And it's maybe one way of thinking of it is the difference between sources for a reporter and witnesses for a prosecution. So a lot of the reporting refers to anonymous sources that have information about what's happened at Mar-a-Lago and different parts of the episode. And there seem to, in many instances, be first-hand accounts, but people who aren't willing to come forward otherwise with their name on the record. And one question I have is, how do we think about the likelihood that those same individuals will be willing to be witnesses or can be made to be witnesses in a trial? What should the public understand in terms of the differences and the incentives or the pressures on these people, and especially, I guess, in a certain sense, this day and age in which people are facing potentially very serious threats to their lives and their families from coming forward?
I'm going to take a first stab at that only because I think that your question is so good. We are, as journalists, in the same soup with the FBI and the prosecutors to some extent right now. We at the Washington Post have had sources say to us, if you come close to identifying me, it's just a caution. I'm going to paraphrase this, obviously. But if you come close to identifying me or limiting the universe of people so that someone can figure out who I am, I'll get a subpoena. And so people know that if they haven't already spoken to the government, that they are in a situation where they do have information the government would like. I think, just to point out, let me jump away from that subject for a second to talk about what Andrew mentioned about Alex Cross. When we learned that Alex Cross had firsthand information about being told, what do we care about? We care about front row seat. We don't want to hear gossip. We don't want to hear secondhand removed. If we're going to publish something like Nuclear Secrets or at Mar-a-Lago, we want someone who saw it or was briefed on it and has we always say front row seat. And so we learned Alex Cross was a front row seat, and my colleagues, I can't take credit for this, my colleagues did amazing reporting to establish that he was, according to our sources, instructed by the president to say much earlier that all the records had been returned to the National Archives. His direct words in the ears of Alex Cross's voice. So I'm pretty sure Alex Cross is going to get a subpoena since we published that story. I'm pretty sure if I were in Andrew or Mary's former jobs, he'd be somebody I'd want to talk to. So it's a tense place for a lot of people. A lot of people gave Donald Trump good advice, and he ignored it. And now some of those people and their aides and people in the room are sharing with us how that advice was rebuffed.
I would just add to that, sometimes DOJ or FBI is going to learn about a potential source from the
I
newspaper.
apologize. I kept saying Alex Cross.
You meant
I meant Cannon.
Right? I think we knew what you meant, yeah. Because I thought, the same last name as the judge.
The good canon.
Yeah, the good canon. So many canons. Sometimes it is something that, they've seen in news reporting, but there's plenty of other ways as well to develop sources, right? And there's also a subpoena power that the press doesn't have. And so it's a matter, when you're talking about simply figuring out who you want to talk to, one source might be journalism, but others is just, you start talking to the people who were at Mar-a-Lago, the people who were in Trump's orbit, people who might have been there when foreign guests were there, all these various people who were at the White House when they were packing up the boxes, people who drove the truck, right? You can go on and on and on. Some will say, I'm not talking to you without a subpoena. Some will talk to the FBI without a subpoena or the Department of Justice. And if they don't want to talk without a subpoena, they will be served with a subpoena. So the department has tools that aren't available to the press that make it very different in that respect. And I should just make clear, I'm sure, most of your lawyers or law students realize that, to issue a subpoena means there has to be a grand jury investigation open somewhere, right? The department doesn't get to just issue them whenever they want. You have to have opened a grand jury investigation. And one thing we do know here is that that grand jury investigation that was opened, that is where the subpoena for the return of documents, the June subpoena, that was issued out of a DC, based on a DC grand jury investigation. So we know there's an investigation open. We know that there's people being subpoenaed, documents being subpoenaed, business records and things like that can be subpoenaed. And that will also often lead to additional resources, right? If you do other types of business records that lead to sources. So now willingness to testify becomes another issue, right? A person, you always want, as a prosecutor, I always wanted to have a relationship where I didn't require a subpoena and where people wanted to come help and do their part and tell the truth. But, you will use a subpoena when you have to use a subpoena, and that includes for trial as well as testimony in the grand jury. You can't use it just to talk to you, right? You can't say, come to my office to talk to me with a subpoena. You have to be using it to actually present information to a grand jury or present it to a trial. But one thing a prosecutor can say is, we can do it that way if you want, and then you're just in there cold without us even having had a chance to talk first, or we can talk first, and we can then talk about what I would ask you in the grand jury and what you're comfortable with. And prosecutors can also talk about safety arrangements. This is usually something we think about in violent crime cases, but it's not unheard of to be a concern in a white-collar case or a case involving political actors like this, and there are things that can be done to help ensure safety, even including security arrangements with marshals or others, or including just other moving people if necessary, things like that. So I'm not trying to suggest it's easy, but there are a lot of tools available.
One quick point is, although the press can be really helpful in a high-profile case when you're in the government, because you can learn things and the press can get ahead of you, and sometimes in helpful ways. But the ways in which it's not helpful is it can be very hard to get people to tell the truth about what they know in two situations. One, if they can plausibly say they don't recall, they don't have real liability, but they just don't want to get involved because it's such a high-profile matter, that the chances of that go way up, that you're going to get I don't know and I don't recall, because people just don't want to be involved and don't want to end up on the front page of the Washington Post or the New York Times. And the other is it's very hard to flip people when the fall is not just saying they did something wrong, but saying they did something wrong where it's covered on the front page of the Washington Post. And that both of those are distinct problems in extremely high-profile matters.
So another question I want to put on the table, and then maybe to you first, Bob, is the role or relationship of the White House and the president when there's an ongoing criminal investigation. And in this particular instance, that the White House has tried to stay very far away from the criminal investigation, but how that can actually be accomplished, given that we're also dealing with something that entails a potential counterintelligence threat, that we have the entire U.S. intelligence community currently engaging in a damage assessment to see what risks have been created by this information being out in the wild. How can you really kind of keep that away or behind the firewall from the White House or the cabinet being able to discuss those kinds of national security issues? So it's a criminal case, but it's a major national security concern. How do you kind of deal with those kind of competing institutional interests?
Well, I will certainly, I believe, though I'm not at the moment able to, specify in any detail any the various ways that I think that the intelligence issues can be separated from the fundamental objective implicated in the norm that calls for distance between the White House and departmental prosecutorial decisions. I think there are ways that the intelligence implications that the president has to be confronted with or may have to be confronted with, the intelligence issues might be teed up in a separate context in a particular way that nonetheless permits that separation between the White House and the department to be observed. There's an interesting point in my work here and elsewhere and in classes with students. I do want to emphasize it is a norm and only a norm by which the presidents absent themselves from federal law enforcement decisions. They're not required to do so in any way, and it is not correct to say as a formal constitutional matter the Department of Justice is independent. It's not any more independent than the Department of Commerce. However, there's a general and I think correct belief that has been transformed into a norm or an expectation of conduct on the part of presidents and White Houses, that the risks of politicized prosecution, the risk of misuse of the law enforcement process for the wrong ends, is so serious that the White House has to keep its distance from decisions about prosecution. So, for example, the president doesn't tell the White House counsel, I'd really be interested to know how far along they are in the analysis of Donald Trump's liability and how close they might be willing to indict. Will you, White House counsel, call the Deputy Attorney General and find out what the status of the case is? Won't happen. Wouldn't happen under Biden. I can't speak to what happened under Trump. I'm not in that business.
I think we know it did happen.
I said I wasn't. I didn't say I didn't
Where are
know.
you with prosecuting Andy McCabe? Come on.
I didn't say I didn't know. I said I wasn't going to speak to it.
Oh, okay.
But it didn't happen in the Obama White House, to be sure. And in fact, I will give you an example, which I think is somewhat helpful on this score. It's actually injurious in some respects to the president's interests, although I think, incidentally, it's overcome by the countervailing considerations built into this norm, to have the department operate, quote unquote, independently. When I was White House counsel, I'll omit the names of parties involved here. I remember walking to my office one morning, and there on the desk was the charging instrument for a case that was going to be announced later that morning by the Department of Justice, of which we didn't have any prior notification. We knew that from the press reports that an investigation was ongoing, conducted by a U.S. attorney, but we didn't know how it was going to end up, and lo and behold, there was the charging document, and it was done. It was over. It was about to be announced, same day. And I looked at it and I thought, this is really a bad decision. This is just, I knew something about the subject matter, which, by the way, was typically not true when I was White House counsel. But I was very good at bluffing my way through that ignorance, which you have to do to survive in the federal government. So, I know all about that. I didn't. But in this case, I looked at the charging document, and I knew a lot about the subject matter. I thought, what a foolish decision this was. And it wasn't going to end up well, and it didn't end up well. And I could have predicted it wouldn't end up well. But even if I had had advance notice and I thought it's going in the wrong direction, I would not have, nor would have President Obama instructed me to call the Department of Justice and say, why in the world are you bringing that case? You're going to lose, and it's going to reflect poorly on the administration. Last thing, the difficulty of this whole area is manifested by something else. Imagine a president who has campaigned, as like, for example, Bernie Sanders has campaigned, on the question of, corporate, the failure of the United States government to hold major companies accountable for corporate crimes of one kind or another. And one day, President Sanders, the sequel, reads in the Washington Post an article that lays out an apparent story about an executive of a major company who was involved in some horrific behavior in one industry or the other, something that just smacks of basis for investigation. President campaigned on accountability. President goes to the Oval Office in the morning, picks up the phone, calls the Attorney General and says, damn it, you better have a good reason not to investigate that SOB. Presidents don't do that. President Sanders, the sequel, would say, but I campaigned on that. That's the Department of Justice I campaigned to have. And you're telling me I can't do it? No, Mr. President, there's a norm that counsels against it. So this is a complicated area, but I will say that the considerations built into the norm against intervention outweigh, I think, the other interests that are adversely affected by the application of the norm.
I'm so sorry, Ryan, if I'm interrupting your train of thought, but that just makes me have a lot of questions for my fellow panelists. So as journalists, we're watching this unfold, and we are picking up vibes that actually the appearance of political, of being political has paralyzed this investigation. Andrew and I have been on a couple other panels on television together where, and Neil Katyal, who you guys may have seen here as well, where we have said a version of, if it had been my house that was raided, I'd be in cuffs the next day because I instructed somebody or I misled somebody about these records, and they're at my house. I mean, I've seen military aides charged with such a shred of material and such a shred of the evidence on the table, charged and court-martialed. So how much are politics, I'd love to hear what you guys think, how much do you think politics is actually changing this investigation and corrupting it in a different way?
Anybody?
Okay. I'll be brief. I couldn't speak to what's going on right now in the Department of Justice, but I would say this. This goes to the whole question of the range of immunities, both formal when in office and by norm when out of office, that we have carved out for presidents and former presidents. When in office, by executive branch law, a president can be investigated but not prosecuted by law, which has made, by the way, the pursuit of the office possibly, again, more appealing for Donald Trump. So think about that. A president who's under criminal investigation says, I need the office back because I like the immunity that goes with it. Okay. And then as a former president, we do recognize we don't want to go down the road in this country, set a precedent by which former administrations or current administrations might wind up, upon taking office, immediately initiating criminal investigations of the prior administration. We haven't had that in this country, which is why this case presents such enormous complexities. So at the end of the day, it is impossible, and I'm going to give you one analogy, it's impossible to imagine that when the department starts to weigh whether prosecution is in order, and I'm speaking now hypothetically, this is not based on any information, they will look in the first instance, is the case a strong case on the merits, that we have a basis upon which to proceed and win before a jury? And then what are the discretionary factors we could take into an account? And an analogy would be, prosecutors who say, I could prosecute on this aggressive theory the head of this investment banking house in New York, but I'm really concerned that it's a weak case, it's a case we could still lose, and in any event, it would be destabilizing to the financial industry. And here you have, I could prosecute, but it would be destabilizing to a highly polarized American politics. And I think the sub-question I would ask is, who actually ultimately is responsible for that decision? Is it the Attorney General of the United States, the identity of whom is probably unknown to 95% of the American public, 94% of the American public? Or does the responsibility, real or actual, or imagined, or an appearance, reside with the head of the executive branch, who will be, because if a former president is prosecuted, it will be assumed that the current administration, widely assumed, that the current administration didn't pursue prosecution without at least the tacit agreement of the incumbent president.
Thoughts?
My own sense is that, well, one, there's a huge difference between politics in the sense of the White House weighing in, the thing that Bob talked about, and politics that's coming from sort of within the department in terms of how they're thinking about the case. I generally sense that the former president has been treated better, as you've noted, than a sort of average citizen, private citizen, and that the January 6th committee has given cover for a much more robust investigation, and that the Mar-a-Lago matter that probably, and again, this is my just opinion, started as a national security recovery operation, meaning that Merrick Garland and Lisa Monaco felt this enormous pressing need to recover really sensitive national security information, morphed into a criminal case because of the former president's conduct that went over and over again, is now made him, in his case, so much worse than other cases that have been prosecuted. And then to Bob's point about sort of the factors, I mean, my sense from what Merrick Garland has said and the fact that he's really operates as a former judge, that the overriding issue for him on the should question, should the former president be prosecuted as opposed to could he, assuming it is a very strong case, is going to be looking at DOJ precedent as opposed to what he used to look at, which was case law. He's going to be looking to see what they've done in comparable cases. Ryan and I have spent a fair amount of time on that issue. It seems inconceivable to me if he does that the former president won't be prosecuted if you're really trying to treat likes alike, which I think is going to be what he does. And I think that Merrick Garland will leave the sort of larger societal issues about what it will do to the nation to the president in deciding whether somebody gets pardoned or not, but not at least overtly weigh in on that issue. And we'll be thinking of sort of more myopically, for lack of a better term, about what to do.
So if we're all just throwing our 2 cents here, and we've had, a number of us have had these discussions in the past, I think that in addition to all the factors Bob and Andrew have mentioned, that the department will also be, there is no real-like example, right? The closest you would get to, a corrupt president that might have faced, facing charges was Nixon, but he's very different. He resigned and, went away. So, you can find other people, high-level government actors, cabinet secretaries and such, but you're never going to have anything quite exactly like what we have with Trump. It's really sui generis. And so, not that it won't be important, they will be looking internally for precedent, but I think they won't find an answer there. I think they will also be concerned, this doesn't mean they won't do it, but I think they will be concerned about not just the political fallout and the potential for future administrations to just, immediately launch investigations into prior administrations and political enemies. I think they'll also be worried about the potential for violence, political violence in the United States right now on the streets. The former president has already basically done what he always does, a wink, wink, nod, nod. There will be riots. Lindsey Graham has echoed that. They're not saying there shouldn't be. That would be wrong. That would be illegal. That's not the way we do it in America. They're not saying that at all. They're basically doing the same kind of thing that President Trump did before the January 6th attack on the U.S. Capitol. Now, that is not Merrick Garland's burden to bear, but I don't think he can avoid thinking about it, and certainly would have to. This is an area where some type of communications with the White House would be, I think, essential, because I think the country would have to be prepared for what might come with an indictment, and that means the president knowing about it, not getting the sign-off or the blessing, but not blindsiding the president with something like this that could result in violence across America. I talk about some of this stuff because a lot of the work I do actually now does involve political violence, and so it's an area where I'm out meeting with researchers on a regular basis, and Carol's done a lot of reporting on this too, after January 6th and before January 6th, researchers who are in the extremist environment, who are seeing what's happening not just in the virtual space, but in the physical space. So I think that's something that will weigh heavily on everybody, in law enforcement, not necessarily a prohibitive factor. And then the last thing I'll say is, there are a lot of other investigations going on as well, of course, involving the president. And I think Andrew's point is a really good one, and I meant to raise it earlier. We're focusing a lot today, and a lot of the attention does focus on the criminal investigation, but the national security investigation, the damage assessment, is critically important. And I do think that's what drove the subpoena. I think that's what ultimately drove the search warrant, is the intelligence community needed to get a handle on what had been mishandled so that they could start to do the work that they will never be able to complete, because you will never know for sure what damage is done. But they need to know what sources might be at risk, what intelligence collection methods do we need to break down and not use because they've been compromised. They've got to figure out, how do we deal with our allies, foreign governments, and foreign intelligence agencies who share information with us, which might be compromised, which might make them not want to be so, openly sharing with us, and we need those relationships. They'll be worrying about how they recruit sources, and if sources think, well, this is how you're going to protect me, my sensitive material being, at a place where foreign agents can walk freely through the corridors. So there's a huge piece of this. This is about the intelligence harm, and it could be that in the ultimate assessment with other things going on, that's where the focus ends up being, and those are things that have to get weighed as well.
So if there are any questions?
So, other than wanting to register my own agreement with Bob's assessment on executive privilege, I'm curious if Mary and Andrew have an assessment, or how much has the Judge Cannon's opinions delayed, obstructed, messed up the orderliness of the investigation, either criminal or national security?
How much is what?
Judge Cannon's opinion. So, I think that it obviously delayed things, but when you really think about it, it moved fairly quickly to, moving for a stay of her order, which she denied. The department went immediately to the 11th Circuit, which acted very quickly, really, in
One
court.
day.
Yeah, in court years, like dog years, like it's really fast. And so, now we have an expedited appeal. So I think the Trump team's trying mightily to muck up the works, and Judge Cannon has unfortunately, complied with their wishes in many cases. But the courts have worked, I think, to try to correct course. And Judge Deary, by the way, the special master, I think also tried to, move the show along. So ultimately, I think we've lost, not a huge amount of time, because the government had access to the information for use in both the intelligence assessment and the criminal investigation up until that order, and then it was just days before they got it again. I didn't count the days. I don't know maybe a week or something. I don't remember.
There still is, though, a harm right now because you can't use the material that is before the special master.
The other material, yeah.
So that is not the core, but there still are criminal uses that you would want to make of that fingerprinting, for instance, asking questions about it. For witnesses in Mar-a-Lago. So there is an ongoing harm, and time, I mean, when you're somebody under investigation, it is par for the course that you want to delay stuff and throw sand in the gear. So I'm not actually faulting the defense on this. That's what they do, and the government has to deal with it. Judge Cannon, I do fault, because I don't think her decision was based on facts or law. Other than that, it's great. To me, the eye is on the clock. If there is a Republican president, it is highly likely that if there is a charge against the former president, he would be pardoned, or if the case hasn't been brought, that the department would stand down. So if you're looking for accountability, delay is, in this situation, there is a real timeline that needs to be brought, because even if there's an indictment, it takes a long time to get to trial.
So just want to thank the panelists for an extraordinary conversation, for an extraordinary topic. And I know that one of us has to catch a train, two of us have to teach in the next 10 minutes. So please just join me in thanking them.